Hi, I'm Bastian Best, a European patent attorney who helps companies make sense of patents in the digital transformation. And you are listening to IP Fridays.
Hello and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 120 of IP Fridays. Today's interview guest is Bastian Best, an expert in the field of patenting of software and AI, and we are talking about the decision G1 of 19 of the Enlarged Board of Appeals of the European Patent Office, and this decision dealt with the application of AI in simulations, so stay tuned. It will be a very interesting interview for you. And before we jump into the interview, I have some more IP-related news for you. The European Patent Office also has recently decided the case of G4 of 19 in the Large Boards of Appeal on 22nd of June 21. And this was about double patenting. And the headword says a European patent application can be refused if it claims the same subject matter as a European patent which has been granted to the same applicant and does not form part of the state of the art according to article so-and-so, the novelty articles. So if it doesn't form state of the art with regard to novelty. And then it also says the application can be refused on that legal basis, irrespective of whether it was filed on the same date or is an earlier application or a divisional application in respect of, or claims the same priority of as the European patent application leading to the European patent already granted. So this is quite interesting and gives some more legal certainty to applicants going to the European Patent Office. Another thing that just happened is that the Supreme Court of the US has decided some interesting case. On June 21st of 21, the Supreme Court just said that basically over 200 patent judges were improperly appointed, but also it found that the inter partes reviews of the USPTO are constitutional. So the USPTO, the officers at the USPTO can basically decide whether already granted patents can be invalidated or not. Then I also have some news on my own behalf. I will be switching to a much larger patent law firm of Michalski, Hüttermann and Partner, effective 1st of August 21. So stay tuned, and I'm very much looking forward to it. Now, let's jump into the interview with Bastian Best. Welcome to today's interview of IP Fridays. Today's guest is Bastian Best. If you don't know who Bastian is, he is the leading expert in patenting of software and AI. And he currently has his own patent law firm. Before, he was partner at Bardele, one of the largest European IP law firms. And he is a frequent speaker at several conferences. For example, you can listen to him at the Swiss Leaders Dialogue Industry in 23rd of June 2021, or the annual meeting of the National Association of Patent Practitioners on 20th of July 2021. And I'm very grateful that you are on the show. Thank you very much, Bastian.
Thank you very much, Rolf. It's a pleasure to be on the show today. And I'm really curious to talk about my favorite topic.
Yes. So do you want to add anything? Maybe I forgot something. I held it rather short.
Thanks, Rolf. So, I mean, after this introduction, I can probably only lose. So, yeah, as you just said, yeah, my field of passion is really patents for AI or patents for computer-based inventions in general. And that's because I have been a computer guy all my life, basically. So I studied computer science and then eventually became a patent attorney and worked for more than a decade now exclusively on software patents. And that's what I'm doing still today.
Very nice. And good to see that software patents are actually patentable sometimes.
Yes, they are. Yeah.
So, yes, I already mentioned that you are really, in my view, one of the real experts in software and AI patenting in Europe. But before we dive into the new decision of the Enlarged Boards of Appeal of the European Patent Office, maybe you can give our listeners a short overview of the recent developments in Europe with regard to patentability of AI or maybe software. What happened? Where did it move? The case law. Can you explain a little bit?
Sure. So, the specific thing about the European patent system is, I would say that, let's say the conceptual framework is really stable and it has been in place for over a decade. It's really stable. Also concerning the patentability of software on a conceptual level, because we have the convict approach, which in a nutshell basically says that the decisive question in the end is always inventive step, obviousness, right? And here the convict approach basically says that you have to figure out which part of the invention in your patent claim contributes to the solution of a technical problem. Only that part can enter into the obviousness assessment, and the whole non-technical part is just disregarded, basically. So that's the conceptual approach, which has been around for quite some time and which is, I think quite reliable and predictable. The real music, of course, plays then in the details, because the hinging question then is always what is technical and what is not technical. And here, software is kind of in the mix. You can do all sorts of things with software. You can do technical things and non-technical things alike. So that's where it gets really interesting. And also here we have lots of case law, because the European Patent Office is one of the largest patent offices in the world. Many cases go on appeal, so we have lots of case law to draw conclusions from. In the field of AI, however, that's a relatively new field for patent timeframes. So there is not so much case law around. In fact, there's also a second source of information in the European patent system, the guidelines for examination, which is basically a large textbook for patent examiners. And they added a new chapter about AI and machine learning, which I have some concerns with, I have to say. Maybe we get into that later then.
Yes, but can you maybe give our listeners a short, brief summary? Like, are there guidelines? What is technical and what is not technical? Is there like a red line somewhere where it's not technical anymore, or is that a case-by-case decision?
In the end, it's a case-by-case decision. So there's no blacklist and also no whitelist in the law. This notion of technicality is left open deliberately. Because the idea is that, our world evolves and the understanding of technology should also evolve. And so the patent system should be adaptable to that. So what we can say right now, the status quo is, as it is codified right now in the guidelines, that, let's say, the computational models underlying machine learning, so the neural networks, the training algorithms, regression algorithms, things like that, these things are considered by the European Patent Office to be mathematical constructs, and those are considered in themselves non-technical by the EPO. That's a pretty clear statement in the guidelines. So which means then in practice that right now, I would say improvements in core AI. So if you come up with a new kind of neural network, a new structure which just operates faster, or if you invent a new training algorithm which just converges faster, and even if every AI scientist would be completely stunned how fast it is, you will not get a European patent on this innovation, because it's just a mathematical innovation for the EPO, but not a technical invention. AI becomes technical then either if you apply it to really solve a technical problem in the, let's say, in the classical technical world. If you use AI, I don't know, to control your machinery in the production plant, for example, or if you really have a specific technical implementation of your AI algorithm.
Okay, for example, if you have new protocols, how to transfer data between the AI, basically an AI server and an AI client, or for example, if you use AI to increase the security of a computer system, maybe, or something like that.
Exactly. Yeah, that would be good examples. Yeah.
Right. Okay.
So in the nutshell is always, let's say, theoretical improvements in AI are not patentable because that's more on the mathematical side, but applied AI, if you apply machine learning to do something in the real world, then it gets patentable at the EPO currently.
Okay, so now there has been a decision of the Enlarged Boards of Appeal of the EPO about simulations and AI used in simulations. What has led to that decision, and when did it come out? That was quite recent, right?
Yeah, the decision itself came out in March 10, so roughly 3 months ago. But there's a long history of this case, so maybe generally how these things work in the European patent system is that originally there was just a normal patent application. In fact, this one, it was filed in 2003, I think, so quite a while ago. It was refused by the patent examiner, and then you can go on appeal to appeal against the refusal decision. The case then gets handed over to one of the technical boards of appeal, and they then essentially decide for themselves whether the first instance refusal was correct or not. And normally you get a decision, then a final decision by the technical board of appeal. In this case, however, the technical board in charge was intending to deviate from an earlier decision. And in those cases where either, let's say, a fundamental point of law is at stake, or when one board tends to deviate from another board, they can then refer questions to the Enlarged Board of Appeal, which is then really the final judicial instance in the European patent system. And this happened in that case. So the Technical Board of Appeal referred certain questions to the Enlarged Board. The Enlarged Board then gave the opportunity for everyone to file observations, so-called amicus curiae briefs. There were, I think, in the range of roughly 20 briefs maybe submitted from various stakeholders, from many patent firms, but also from patent applicants in the simulation field. And then there was an oral hearing. This was in July last year, so already during the pandemic. So this, it was actually streamed. It was the first Enlarged Board of Appeal hearing, which was streamed live over the internet. So everyone, because these hearings are public, everyone could register. And then I also watched it. And then it took after the oral hearing, it took the Enlarged Board roughly 8 months now to come up with the written decision then.
Okay, maybe can you explain the underlying patent application, briefly summarize what it was about and why it was refused maybe, and maybe you can already briefly summarize the decision, like what was the outcome?
Yeah. So just briefly, so the invention in this case was about simulating pedestrian crowd movements. So the use case is basically that, consider that if you are, let's say, an architect and you want to build a new airport or a train station or a soccer stadium, maybe. So these are rather complex projects. So instead of building the whole thing and then figuring out that, I don't know, the emergency ways are too small or something like that, you could do prototypes, of course, smaller scale prototypes, but the invention was about simulating crowd movements through such an environment. So basically what you would have is you would have a model of the environment you are intending to build. So a definition of where the ground floor and where the walls are, where the doors are, things like that, all in a model. And then you would have a mathematical model of how a pedestrian would move in such an environment with certain rules. Of course, a pedestrian cannot move through walls and other obstacles, things like that. You can all model all of that mathematically. And then you can just, duplicate your pedestrian model. So you have a crowd of, let's say, 1,000 pedestrians, and then you can just simulate how they move through this environment. And then you can draw conclusions about how this design of the building, whether it meets the requirements or not. So that was what the invention was about. So really a virtual invention, I would say. Yeah, I mean, it sounds maybe rather technical, designing a building and things like that, but in the end, it's all happens in the computer. It's all just a simulation. It's just virtual. One point that is crucial in the end then also is you could also use this kind of simulation not for building an airport, but maybe for, I don't know, controlling how an army should move in a computer game. So there are really technical uses for it and also maybe non-technical uses. So in the first instance, the examiner refused the application because he said, well, the whole simulation part is non-technical and doesn't contribute to inventive step. So the case went on appeal, and the technical board of appeal said they took a very, very strict stance. At one point, they said that according to their opinion, the question of technical character requires at a minimum a direct link with physical reality. So that was one statement I was really concerned about whether the enlarged board would confirm that or not. And also, I mean, they deviated from this earlier case law, which spoke in favor of the patentability of simulation methods, as long as what you are simulating is a technical system.
Okay. So what was decided then? What did the enlarged board of appeal say?
I mean, it's a long and really densely written decision. It's 65 pages roughly in total. So all in all, it's a really I would say a nice piece of legal work here. It's certainly, so there's really no short answer, simulations, yes or no. But overall, I would say my key takeaways are that the decision is really no revolution, but it's also no regression. So that was my main concern. But it's really a controlled evolution of what we already have, I would say. So on the one hand, the decision clearly confirms that the conceptual framework I was explaining in the beginning, the convict approach, is the way to assess computer implemented inventions, and it also applies to simulations. So this conceptual framework is confirmed. And on the other hand, the decision really leaves the door open for future developments. That's a good thing, in my opinion, in particular concerning this notion of technicality, because as I said, the referring board took this, in my view, really, really conservative point of view that basically you always need a direct link to physical reality. So which would mean you could only patent really embedded software in the end, where you either really measure data using sensors on the input side, or where you really control some kind of machinery or some kind of technical process on the output side. That's this direct link which was required by the referring board. And here the enlarged board explicitly now says that this direct link with physical reality is maybe a sufficient criterion in many cases, but it's not a necessary one. That's an outcome I really like. Also, this notion that there is no and should never be an exhaustive definition of technicality. So this leaves the door open, as I said, for future developments. And then last of all, there is, when we get into the nitty-gritty details of the decision, there are lots of statements in there which, can help to argue in favor of the technicality of software-based inventions in the future.
But as a result, the application was refused.
The enlarged board did not decide on the specific application. They just answer, the job of the enlarged board is just to answer the questions that are referred to them, and that they did. So they just gave, let's say, general guidelines for this field, for the field of simulations. Now, interestingly, on the other hand, the case now came back to the original technical board, which was referring, and now the case came back. And in the meantime, this referring board now scheduled an oral hearing. For, I think it will happen in November, the oral hearing, and they also issued a preliminary opinion. And in that preliminary opinion, they say that, now the enlarged board has rendered its decision and it gives useful guidance. And they say that they jump on one point the enlarged board was mentioning, and this is that calculated technical effects. So in a simulation, I mean, the output, the effect is really only a virtual one. It only happens in a computer. It's not a material one in the real world, but it's just a calculated technical effect. And they say that in this case, now we know that the output of the invention here is really the behavior of a crowd moving through the environment, and that is not a technical effect in that sense. The referring board, the technical board, still intends to refuse the application.
Okay. Bad luck for the patent applicant.
But he has done, nevertheless, a great job in advancing the European case law. So merits for that.
So, but what does this decision mean for the patentability of AI or simulations in particular for the future? What is your takeaway for the future? Does that change your point of view or how you draft patent applications in that field?
I think it doesn't really change the fundamentals, as I said, but in the details there are a number of helpful statements in the decision which help us patent attorneys make arguments in favor of the patentability of AI. I mean, one point I'm always fighting with is, as I said in the beginning, this aspect that innovations in core AI, irrespective of whether the application is then technical or not, whether that is patentable or not. And now that the board, the enlarged board, has explicitly stated that the notion of technicality is really open and should be adaptable to the future developments. My argument would be, that machine learning is one of the core technologies of the future, no doubt. And so this should really be considered to be a technical field. So from that point, you could use the G1 of 19 to make the case, but in the end, it's really left open.
Okay.
There are concerning the patentability of machine learning inventions. I mean, aside from this whole technicality aspect, there are also other interesting points right now in the European patent system. One of them being disclosure of the invention, for example, which can be kind of tricky for AI inventions.
So would you recommend to US patent practitioners who are among our listeners, a lot of our listeners are from the US, to carefully read this decision to get hints and tips how to draft a US patent application that then enters into the EP phase at a later stage?
Yeah, I mean, of course, that makes sense. Of course, yeah, that's always what I try to explain US clients that it's a good thing for important cases, at least before the priority application is filed in the US, to hand it to the European representative. To just amend the priority application for each target jurisdiction for that matter. And I mean, on the one hand, in the US, there are, of course, I mean, the discussion is more about patent eligibility, I understand, and less about the obviousness hurdle. But at least what I hear from my US friends is that if you can make it in Europe, if you can convince the European patent office that there's a technical contribution, that's also helpful for the USPTO. So in that sense, yes, of course, it makes sense to study the decision.
So, and then maybe my last question before we wrap up. Where do you see the biggest challenges for patenting of AI in Europe? What do you think is the biggest obstacle? You already mentioned inventive step, but what does it mean in particular? And are there other criteria that may be important to look at?
Yeah. It's really, I would say, it's really inventive step, and what we just talked about, this technicality question. I hope that there will be future decisions of the boards of appeal that really clarify or give some more guidance, which is a more, let's say, more elaborated than this, for me, rather too absolute statement in the guidelines that the mathematical foundations are just out of the scope of the European patent system. That's my hope on the technicality front, so to say. And in practice, really, if we move away from the core AI innovations and if we look at really if inventions are about applying AI for a certain use case, then the invention is oftentimes not about a new training algorithm, but really about how to apply it to a specific domain. And here the question is, in fact, oftentimes the situation is oftentimes that the applicant on the one hand wants to get a patent on using AI for that use case, but on the other hand they do not want to disclose how they do it specifically, because the main efforts go into how the neural network is trained and how the model is built, and that's something that applicants tend to want to keep secret. So there's this dilemma between you want a monopoly on the one hand, but to get a patent you have to disclose how it works, and you don't want to disclose your training data, your model, and so that's the tricky point, to get a disclosure in the patent application which is sufficient to get a patent, and to not to reveal the secret source. That's tricky in practice.
Do you need to disclose like sample training data, or do you need to disclose like a sample training algorithm, even if it's not the optimum, just to show that, to demonstrate that the invention is workable?
Yeah, as I said, so on these detailed aspects, there's not much case law around yet, but there are some decisions. 2 decisions come to mind, from recent decisions from the technical boards of appeal, which really refused patent applications because they didn't reveal how the neural network was trained in a nutshell. So in that case, the technical board really asked for at least one specific training data set, I think was the wording. So yeah, it makes sense to disclose at least some training data and at least some examples of how the AI is trained. And you already mentioned it. Yeah, sometimes it's maybe there's no requirement in the European patent law to give the best mode. So yeah, in Europe, you could theoretically disclose one possible way of training the neural network, which works, but which is probably not the absolute optimum. Yeah, that's maybe a good trade-off.
Okay. Yeah. So, if people want to learn more about you and want to get in touch with you after this interview, where do you want to send them?
Yeah, well, you already mentioned that I'm doing this podcast, which is produced very, very amateurish, I would say, compared to yours. But nevertheless, maybe it's interesting. On the one hand, so my overall content hub, so to say, is really my website, bastianbest.com. There you will find links to everything I put out there. I put out lots of free stuff, including the podcast, YouTube, and I'm quite active on LinkedIn also, if you want to connect there.
All right. So I'm linking your LinkedIn profile and your homepage in the show notes so people can easily reach you. Thank you very much for being on the show.
Thank you, Rolf. This was great. Thank you.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.